Hello friends, welcome to the world of Companies Act 2013. Yes my friends, in this video we are going to revise our chapter number 5 of Companies Act 2013. Chapter number 5 of Companies Act 2013 deals with the provisions towards acceptance of deposits by companies. Yes, chapter number 5 has covered the provisions from section number 73 up to section number 76A of Companies Act 2013. In this entire chapter 5, section number 75, in this entire chapter number 5, section number 75 is been omitted from our syllabus. Over here, whenever a company wants to raise the funds, one of the way through which the company can raise the funds is by acceptance of deposits. It is by acceptance of deposits. Whenever a company will be raising the funds through acceptance of deposits, then yes, the company will have to follow the provisions of chapter number 5 of Companies Act 2013. Along with it, the company also needs to follow Company Rules 2014, which is towards acceptance of deposits. Over here, whenever a company is going to raise the funds through acceptance of deposits, yes, whether you say deposits or whether you say fixed deposits or whether you say public deposits, it's one and the same. So whenever a company is going to raise the funds in a form of a deposit, so yes, it is nothing but a borrowings made by the company. It is nothing but the borrowings made by the companies. So whenever a company is going to raise the funds through acceptance of deposits, it will be considered as a borrowings. Over here, such borrowings can either be secured or it can even be unsecured in nature. Which means what? If the company has created a charge upon its asset for the depositors, then such borrowings are secured borrowings. But if the company has not created any charge upon its asset for its depositors, then such borrowings are unsecured borrowings. Over here in this entire chapter, section number 73 and section number 76. In this entire chapter, section number 73 and section number 76, along with companies' rules towards acceptance of deposits. These three provisions are relevant provisions towards acceptance of deposits. These three provisions are relevant provisions towards acceptance of deposits. Whenever you are a non-banking, non-financial company, whenever you are a non-banking, non-financial company, so yes, in that case, how will your company raise the funds through deposits? That entire provision will be covered under this particular topic. Yes, the lawmaker says that section number 73 and section number 76, see, both of them are very important provisions towards deposits. However, section number 73 and section number 76, section number 73 and section number 76, both of these provisions are not applicable upon a banking company, upon an NBFC, upon a housing finance company and all such other class of companies which are being notified by central government from time to time, which are being notified by central government from time to time. So whenever these companies are going to raise the funds through deposits, are not going to follow the provisions of section number 73 and section number 76. In fact, whenever these companies are going to accept deposits, they will be following their own norms, they will be following their own rules and regulations. Over here, whenever we talk about deposits, so yes, there are two kinds of deposits. The very first being section number 73 and the second being section number 76. Section number 73, acceptance of deposits from members. Actually, the provision is prohibition of acceptance of deposits from public. Yes, your company will be prohibited to accept deposits from public, which means your company can accept deposits from members. Sir, which company can accept deposits from members? The lawmaker says over here that whether you are a private company or whether you are a public company, whether you are a private company or whether you are a public company, both the companies are allowed to accept deposits from their own members. If you are accepting deposits from your own members, if you are accepting deposits from your own members, then in that case your members will be having a dual capacity. They will be considered as a member, and yes, being a deposit holder, they will also be considered as the creditor of the company. However, section number 76 says that a company can accept deposits from public at large. Which company can accept deposits from public at large? The lawmaker says that only and only an eligible public company, only and only an eligible public company can accept deposits from public at large. What do you mean by eligible companies? We are going to understand that particular part in our section number 76. So let us first begin our journey towards section number 73, which says about acceptance of deposits from members. Over here, whenever we are going to accept deposits from our own members, the lawmaker says the company is over here, first of all, required to pass a resolution. Yes, the company requires to pass a resolution for which the company requires to call a proper general meeting for its member. In that case, the company will have to give an explanation to its members that for what reasons the funds are getting accepted. What is the object of raising the funds through deposits? For what tenure the money will be accepted in a form of deposit? What will be the rate of interest the company will be providing to its deposit holders? Whether they will be secured or whether they will be unsecured, all such necessary details the company needs to first explain to their members. Then only if the member passes a resolution, the company will be allowed to accept deposits from its own members. Over here, whenever the company is going to repay those deposits, whenever the company is going to repay back those deposits, then the company shall repay the deposits along with along with interest. So every deposit accepted by a company, every deposit accepted by a company will always and always be repaid along with interest. So whenever in your life, if you are going to invest your money in a company in a form of a deposit, so in that case, the company where you have invested your money, that company will repay back your money to you along with interest, which will be at fixed rate. What will be the rate of interest? That will already been communicated to you through terms and conditions of an agreement. Yes, whenever the company fails to repay back the deposits, then the depositors can raise a complaint to the tribunal. Yes, the concerned depositors can directly make an application to the tribunal and raise a complaint against the company that the following company had accepted our money in a form of deposit, but now the company has failed to either repay the principal amount or interest or both. Once the tribunal gets such kind of a complaint against the company, the tribunal shall give a direction, the tribunal shall give an order and ask the company to pay its depositors forthwith. Or else, if the depositor has faced any kind of damages, then in such case, the company will be liable to pay such damages to the depositors. Yes, the company has to make a provision for a reserve called as deposits repayment reserve account. See, deposits are going to get matured in a near future. Deposits are going to get matured in a near future. Which means what? Which means what? Over here, in a very near future period, the company requires to have certain amount of money through which the deposits can be repaid. So over here, the company will have to make a provision, the company will have to make a provision, the company will have to make a reserve called as deposit repayment reserve account. See, whatever is the money which will be lying inside this account, that money will be utilized only and only for one purpose, that is for repayment of deposit. That is for repayment of deposit. So whenever a company wants to accept deposits from members or any other person, then yes, all these conditions have to be fulfilled. And yes, there are few more conditions the company needs to follow. There are few more conditions the company need to follow. The lawmaker over here says the company needs to first issue a circular to its members. See, the word circular over here terms as invitation to offer. If the company was going to raise the funds by issuing shares to public at large, then in that case, if you guys remember, we have already revised in our chapter number 3 that the company requires to issue a prospectus. The company requires to issue a prospectus. So over here, when I say prospectus, it is an invitation to offer. Over here in this chapter, circular stands for invitation to offer. So whenever a company is going to raise the funds, whenever the company is going to raise the funds through its members by accepting deposits. See, whether you accept deposits from your members or whether you accept deposits from public at large, the company is always and always bound to issue a circular. The circular over here will be acting as an invitation to offer. Inside this circular, various information the company needs to provide. One of the important information the company needs to provide is about the credit ratings. What is a credit rating? A credit rating determines the credit worthiness of a company. It also tells about the ability of a company to repay. About the ability of a company to repay. Over here, once the company has prepared the circular, before issuing the circular to its members, the company shall first file the copy of the circular to the ROC. The company shall file the copy of the circular to the ROC. Such circular should be filed with ROC at least within 30 days before, at least within 30 days before issuing the circular. So if the company is planning to issue circular on 31st of the month, then yes, the circular should be filed with ROC at least by 1st of that month, at least by 1st of that month. Over here, we had already discussed that a company requires to make a provision for deposits repayment reserve account. See, over here, the money which is lying inside this account will be nothing but considered as a liquid asset which can easily get converted into cash, and through that account the company can easily pay the maturity value to its depositors. Whatever is the amount which is going to get matured in the next financial year, I repeat, whatever is the maturity amount which is going to get matured in the next financial year, at least 20% of that amount, the company shall reserve it in this particular year on or before 30th April. On or before 30th April. And such money will be deposited in a scheduled bank under an account called as Deposit Repayment Reserve Account. So what is the minimum? What is the minimum maintenance of liquid assets required over here? So it is at least 20% of the deposits which are going to get matured in the next financial year. The money which is going to get matured in the next financial year, uska at least 20% should be kept in a reserve, and such reserve should be maintained on or before of 30th April of this particular year. Over here, the company needs to issue a certificate stating that the company had not made any kind of default in last 5 years, either towards repayment of principal amount nor towards repayment of any kind of interest amount. So company has not made any kind of default. Such kind of a certificate will be issued, and the default was neither been made towards the principal amount nor towards the interest. So this point number A, B, C, D, this point number A, B, C, D are mandatorily required to be followed by every company. This point number A, B, C, D is mandatorily required to be followed by every company. However, point number E says that if the company wants to secure its depositors, if the company wants to secure its depositors, then only the company will have to create a charge upon its asset. Then only the company will have to create a charge upon its asset. However, if the company would like to keep their depositors as unsecured, then the company needs to specify the same in their circular. The company needs to specify the same in their circular. However, the above provisions, that is point number A, B, C, D, shall not be applicable to a private company. The above provisions of point number A, B, C, D shall not be applicable to a private company. Sir, which private companies will be having such type of an exception? The lawmaker says any private company which satisfies any one of the given three conditions. If any one of the given three condition, if any one of the given three condition gets fulfilled, and if you are a private company, so yes, you won't be required to fulfill the provisions of point number A, B, C, D, which was there in our previous slide, which was there just in our previous slide. If you are a private company and you are accepting deposits from members, which is up to 100% of the net worth, which is up to 100% of the net worth, then yes, your private company will be exempted from fulfilling the provisions of point number A, B, C, D. But yes, your private company needs to provide the details of money accepted through deposits to ROC. Whatever is the money the company accepted, those details the company needs to provide it to the ROC. Or else the second reason says that if you are a private company which is a startup company, you are a private company which is a startup company, and till now 5 years have not been elapsed from your date of incorporation. Till now 5 years have not been elapsed from your date of incorporation, then yes, even your private company will not be required to fulfill the provisions of point number A, B, C and D. Or else you are a private company which fulfills all the given three conditions. You are a private company which fulfills all the given three conditions. That is number one, you are a private company and you are not an associate or you are not a subsidiary of any other company. You are neither an associate company, you are neither a subsidiary company. Plus, the borrowings of your company is not exceeding twice the paid up capital or 50 crores, whichever is lower. And yes, your company is not making any kind of default towards such existing borrowings. The lawmaker says that every company whosoever is going to accept deposits shall always and always file the details to the ROC under a form called as DPT3, under a form called as DPT3. So yes, my dear friends, we have successfully revised our provision towards section number 73 of Companies Act 2013. The next provision says about acceptance of deposits from public at large. Section number 76 says that only and only an eligible company can accept deposits from public at large. Only and only an eligible company can accept deposits from public at large, which means you need to be an eligible company plus a public company. Sir, if a private company is eligible, can they accept deposits from public at large? No, because a private company is been prohibited to accept deposits from public at large. So only and only if you are, only and only if you are a public company and you are eligible to accept deposits, then only you can accept deposits from public at large. What do you mean by eligible company? The lawmaker says the net worth is greater than equal to 100 crores or the turnover is greater than equal to 500 crores. So only and only if you are an eligible public company, you are allowed to accept deposits from public at large. For that reason, your company needs to first call a general meeting and pass a special resolution. Only when a special resolution will have get passed, only when a special resolution would have got passed, then only your company can accept deposits from public at large. But wait, if in your company the proposed deposits, if in your company the proposed deposits plus the existing borrowings, the proposed deposits plus the existing borrowings is lesser than equal to the paid up capital plus free reserves plus securities premium. If the proposed deposits along with the existing borrowings is lesser than equal to the paid up capital plus free reserves plus securities premium, then in that case, your company can even accept deposits from public at large by just passing an ordinary resolution. By just passing an ordinary resolution. Whenever you are an eligible company, so always and always remember that eligible company shall require to get something called as a credit ratings from a recognized credit rating agency, and such credit ratings they should get on year to year basis. Such credit ratings they should get on year to year basis. If you are going to accept deposits from public at large, and if you are inviting a secured deposits, if your company is inviting a secured deposit, then yes, it is the duty of the company to create a charge upon its asset within 30 days of such acceptance, within 30 days of such acceptance of deposits. So yes, my dear friends, we have successfully completed the provision of section number 73 as well as section number 76. So let us begin the next provision, that is section number 74. Section number 74 says about repayment of deposits which were being accepted before the commencement of Companies Act 2013. Which means if your company has accepted a deposit as per the previous Companies Act 1956, if the company had accepted the deposits under the old law, that is under the Companies Act 1956, and such deposits are yet to get matured, and in meantime Companies Act 2013 got introduced, then all such deposits which were being accepted before the commencement of this act should be repaid. The lawmaker says, first of all, the company requires to file a statement about such deposits to the ROC within a period of 3 months from the commencement of this act. Within a period of 3 months from the commencement of this act. In fact, all such deposits shall be repaid within 3 years from the commencement of this act or the actual date of repayment, whichever is earlier. However, if your company is going for renewal of such deposits, then the renewal should be done as per the provisions of chapter number 5 of this act, that is Companies Act 2013. If your company is not in a position to repay such deposits and your company wants some kind of extension of time limit, then yes, the company has to make an application to the tribunal. The company is required to make an application to the tribunal, wherein tribunal, after considering the financial consideration, after considering the financial condition of your company, only after considering the financial condition of your company, the tribunal might allow the company some kind of extensions. The tribunal might allow a company some kind of further time limits. If any of the provision of section number 74 is been contravened, if any of the provision of section number 74 is been contravened, then in that case, the company as well as the officer in default, then in that case the company as well as the officer in default shall be punishable. The company will be punished by asking to pay a penalty of minimum 1 crore, maximum 10 crores. Officer in default will be asked to pay a minimum penalty of 25 lakhs, maximum 2 crores, or else the officer in default can be sent for an imprisonment up to 7 years, or there can be both the things, Over here, the last provision of this chapter is section number 76A. Section number 76A says that whenever a company contravenes any of the provision of section 73 or section number 76. See, what is section number 73? Section number 73 deals with prohibition on acceptance of deposits from public at large, which means a company is allowed to accept deposits from its members, for which certain terms and conditions are required to be followed, which we have already revised in our section number 73. If any of those conditions are been contravened, then yes, the company as well as officer in default will be punished as per section number 76A, Section number 76 says about acceptance of deposits from public at large, for which also there were certain conditions which were required to be followed. If the company contravenes any of those provisions, then yes, the company along with officer in default would be punished as per section number 76A. What is the punishment over here? The lawmaker says that the company will be punished with a penalty of minimum 1 crore, or twice the amount which was been accepted as deposit, whichever is lower. Either 1 crore or twice the amount of deposit accepted, whichever is lower. That is the minimum penalty. The maximum penalty can be of up to 10 crores. The maximum penalty can be of up to 10 crores. The lawmaker over here says that officer in default will be asked to go for an imprisonment up to 7 years. Along with it, the officer in default will also be asked to pay a minimum penalty of 25 lakhs up to 2 crores. If the officer in default is been proved to be guilty of fraud, then yes, he will also be asked to go for the penalty under section number 447, which deals with penalty for fraud, So yes, my dear friends, we have successfully revised our entire provision of this chapter called as chapter number 5 of Companies Act 2013. Yes, my dear friends, let us move on towards the next part of this chapter, that is about the rules for acceptance of deposits. All these rules are given under Company Rules 2014. The lawmaker says over here that whenever a company wants to raise the funds by acceptance of deposits, then that company can accept deposit for a period not lesser than 6 months. The maximum period for which the deposit can be accepted is of 36 months. Whether you talk about new deposit or whether you talk about the renewal ones, it remains the same. Over here, if the company wants something called as a short-term requirements of funds, then in that case, the deposit which can be accepted by a company can be lesser than 6 months, but it should not be lesser than 3 months. The maximum amount under which the company can go for a short-term deposit, it is 10% of its paid up capital plus free reserves plus securities premium. Over here, one single deposit receipt can be jointly held by maximum 3 depositors. So just like our joint shareholders, we have got joint depositors wherein it cannot be exceeding 3 in one deposit receipt. The next rule says about the ceiling limits for acceptance of deposits. The ceiling limits for acceptance of deposits. See, the ceiling limits will differ from company to company. If you are a company which is an eligible company, if you are a company which is an eligible company, then yes, you can accept deposits from members as well as public at large. The maximum amount an eligible company can accept deposits from their own members, it is 10% of paid up capital plus free reserves plus securities premium. The maximum amount of deposit a company can accept from public at large, wherein the company is an eligible company, it will be 25% of paid up capital plus free reserves plus securities premium. Over here, the lawmaker says that if you are a company which is other than eligible company, if you are a company which is other than eligible company, then yes, your company can accept deposits from members, wherein the maximum limit permissible is 35% of paid up capital plus free reserves plus securities premium. Over here, if you are a company which is a government company and which is eligible in nature, if you are a company which is government company and yes, you are eligible in nature, then yes, your company can accept deposit up to 35% of paid up capital plus free reserves plus securities premium. So the ceiling limits for acceptance of deposits will be changing from company to company. Depending upon a type of a company, the eligibility goes on changing. Over here, the lawmaker says that if you are a company which is a specified IFSC public company, if you are a company which is a specified IFSC public company, and if you are going to accept deposits only and only from your members, then yes, the limit for you is 100% of paid up capital plus free reserves plus securities premium. The last company over here left out is a private company. See, whenever you are a private company, then yes, your private company can accept deposits only and only from members, when the ceiling limit is 100% of paid up capital plus free reserves plus securities premium. However, the lawmaker says that if you are a private company which is a startup company, you are a private company which is a startup company, or else you are a private company which is neither an associate company nor a subsidiary company, and your borrowings is lesser than twice the paid up capital or 50 crores, whichever is lower, and there is no subsisting default upon such borrowings, then For you guys, the limit will be prescribed by central government. For you guys, the limit will be prescribed by central government. Central government will decide that what should be the limit for such private company in order to accept deposit, in order to accept deposits. Okay. The next rule over here is upon the ceiling limits for the rate of interest and brokerages. A company is not allowed to provide rate of interest which is greater than the limits prescribed by RBI for NBFCs. Similar way even for the brokerages. The lawmaker says over here that once the circular is been issued, and the deposits are been accepted, then the company is not allowed to alter any kind of terms and conditions either inside the deposit trust deed or inside the deposit insurance contract or inside the terms and conditions of the circular itself. So once the circular is been issued and the deposits are been accepted, the company is not allowed to alter any of the terms and conditions either inside the circular or inside the deposit trust deed or inside the deposit insurance contract. The lawmaker says over here that if you are an eligible company, then yes, on year basis, the eligible company needs to get something called as a credit ratings from a credit rating agency. The credit rating is nothing but it signifies, it will tell us about the ability of a company to repay back the deposits. Whatever is the credit rating, the company needs to intimate to the ROC under a form called as DPT3. Over here, what is the minimum credit rating required? The lawmaker says the credit rating shall not be below the minimum investment grade ratings. It shall not be lower than the minimum investment grade ratings. Over here, whenever your company is going to accept deposits, whether your company is other than eligible company or whether your company is an eligible company, in both the situation, the company needs to issue a circular. Yes, my dear friend, circular over here means invitation to offer. Circular over here means invitation to offer. So whether your company is a company other than eligible company means your company is going to accept deposits only from members. Your company is going to accept deposits only from members. Okay, if your company is an eligible company, means your company can accept deposits from public at large as well as from members of the company. Before accepting the deposits, the company needs to issue an invitation to offer, that is nothing but a circular. Over here, the lawmaker says that the circular will be prepared as per form number DPT1. The circular will be issued to the members either by registered post with acknowledgement due or through speed post or even by electronic mode. The circular will even be published in a newspaper, that is English newspaper as well as vernacular newspaper. The company needs to get a certificate from a statutory auditor stating that the company has not made any kind of default neither towards repayment of deposits nor towards its interest. However, if the default was even been made, then such default was made good and 5 years have already been lapsed since the date of making good the default. Yes, the circular will be always and always issued under the authority and in the name of the board of directors. Sir, what will be the validity of the circular or the advertisement issued by the company in order to accept deposits? The lawmaker says that the invitation to offer, that is the circular or the advertisement, will be having a validity which will be of up to 6 months from the closure of the financial year in which the circular was issued or the day when the annual general meeting was being held and the financial statements were being laid before the members, whichever is earlier. However, if no annual general meeting was being held, then we need to take the last date before which the annual general meeting should have been called upon. Once the validity for the circular comes to an end, and if the company wants to accept new deposits, then the company needs to issue a fresh circular. A company needs to issue a fresh circular once the validity gets expired. Over here, if a company is a company called as an eligible company, then yes, even for them, the circular will be prepared as per a form called as DPT-1. Over here, it will also been published in an English newspaper along with vernacular newspaper. Yes, over here, the circular will also be placed upon the website of the company. It will be issued under the authority and in the name of the board of directors of the company. Over here, the circular will have to get first filed with the ROC, and later on it can be issued to public at large. Over here, the validity of the circular will remain the same, that is up to 6 months from the close of the financial year in which the circular was been issued, or the day when the annual general meeting was being held and the financial statements were being laid before the members, whichever is earlier. If no annual general meeting was being held, then in that case the last day before which the annual general meeting should have been called shall be evaluated. Over here, once the advertisement, that is once the circular's validity comes to an end, and if the company wants to accept new deposit, the company needs to issue a fresh advertisement. Sir, we have understood that till what time limit the circulars will be valid. Sir, but from which time the validity should commence? The lawmaker says that if you had issued a circular through an advertisement in a newspaper, then the day when the advertisement was been given in the newspaper, from that day the validity will begin. However, if you have dispatched a circular, then in that case, the day when the circular was being dispatched will be considered as the effective date through which the validity had begun. Yes, my dear friends, the next rule is about creation of security. Whenever a company is inviting secured deposits, the lawmaker says the day when the deposit was being accepted, from that day within 30 days, the company should create a charge upon its asset. See, charge is a very wide term. It includes mortgage, it includes pledge, it also includes hypothecation. Over here, the lawmaker says that whenever a company is inviting secured deposits, then the company should, within 30 days from the acceptance of such deposit, shall create a charge upon its asset, either by way of mortgage or by way of hypothecation. See what is a mortgage and see what is an hypothecation we have already discussed in detail during our regular lecture. The company can provide such security either by creating a charge upon its asset or even through deposit insurance. But always and always remember, the value of security provided by the company should never be lesser than the amount of deposit, that is the principal amount, along with the interest payable thereon. The next rule is about appointment of trustees for depositors. Whenever a company is going to accept a secure deposit, then in that case the company shall appoint one or more trustees for the depositors. Yes, the company shall execute a deposit trust deed in a form called as DPT-2 at least 7 days before issuing the circular. Sir, what is the function of this deposit trustee? The lawmaker says the deposit trustee will always and always protect the interest of the deposit holders. Yes, it is the duty of the deposit trustee to redress the grievances of the depositors in an effective manner. However, there are few people who are being disqualified to get appointed as a deposit trustee. Lawmaker says that if you are the director of a company, or key managerial personnel of that company, or you are an officer or an employee of either that company or its holding company or its subsidiary company or its associate company, or even if you are a deposit holder, then sorry to say you are being disqualified to get appointed as a deposit trustee. Even if you are a person who has been indebted to the company or its subsidiary company or its holding company or its associate company, then even in that case you are being disqualified to get appointed as a deposit trustee. Whenever you are having any kind of pecuniary relationship with the company, pecuniary stands for monetary. Pecuniary stands for monetary. So even in that case, you will be disqualified to get appointed as a deposit trustee. Even if you have entered into an arrangement for any kind of guarantee, then even in that case, you are being disqualified to get appointed as a deposit trustee. See, all the above mentioned people are being disqualified. In fact, any person related to the above person is also being disqualified to get appointed as a deposit trustee. The lawmaker over here says that once the deposit trustee has been appointed, you cannot remove him before the expiry of his term. You cannot remove him before the expiry of his term. But there is only one exceptional case wherein it says there is a consent of all the directors present in a board meeting, then yes, you can remove a deposit trustee even before expiry of his term. The next rule is about the application form. Whenever a company who is going to accept deposits from its depositor, then yes, the company needs to first receive an application from that intending depositor. Yes, the intending depositor will also give a declaration inside that application stating that whatever money he is investing in a company in a form of a deposit, that money is not being borrowed by him from any other person. If you are interested, then yes, a depositor can appoint a nominee at any time. So any person at any time appoint a nominee. Sir, whom can we nominate? The lawmaker says you can nominate any person at any time. Over here, the next rule is about the deposit receipt. The lawmaker says over here that whenever a company has received the money through a form called as deposit, then the day when such money was been received, then from that day within a period of 21 days the company shall issue a deposit receipt to its depositor. However, if the depositor has given a check, then the day when the check gets realized, from that day within 21 days the company shall issue a deposit receipt. If it is a case of renewal, then yes, the day when the renewal had taken place, from that day within a period of 21 days the company shall issue a deposit receipt to its depositor. Yes, the company is required to go for maintenance of liquid asset wherein at least 20% of the amount which is going to get matured in the following financial year. 20% of the amount which is going to get matured in the following financial year shall be deposited on or by 30th April of this financial year in a scheduled bank in a separate account called as deposit repayment reserve account. Whatever is the money inside this deposit repayment reserve account, that money will always and always be utilized only and only for one purpose, that is for repayment of deposits. The next rule is about register of deposit. Yes, my dear friends, the lawmaker says that the company shall maintain details of its depositors under a register called as Register of Deposits. Such register will be maintained at the registered office of the company. The various details will be given inside the register, that is about the name and address of the depositor, the details of the nominee if appointed, if the depositor is a minor, then the particulars of the guardian, Over here, deposit receipt number. Over here, what is the rate of interest, whether the depositor is secured or unsecured, etc. All such details the company shall maintain inside a register called as register of deposit. Over here, the day when the company has issued a deposit receipt, from that day within 7 days, the entry should be made inside a register called as register of deposit. The entries will be there inside such register for a period for not lesser than 8 years. For a period not lesser than 8 years. Over here, if any depositor is planning for a prematurity, then it is allowed, provided 6 months have expired from the day when he had deposited that money. Prematurity is allowed, but the company will deduct rate of interest, that is a flat rate of 1% will be deducted from the rate of interest. However, there are two situations wherein there will be a prematurity, but it won't result into reduction of rate of interest. These are the two situations wherein the rate of interest will not be reduced even if there is a premature surrender of deposit. However, if the depositor wants to, if a depositor wants to avail higher rate of interest, then in that case he can renew the deposit with the company. But in that case, the company will renew such deposit only when the depositor is renewing the term which is for a period greater than the unexpired period, which should be for a period longer than the unexpired period of the deposit. Over here, the company needs to file the details of deposits under a form called as DPT3 with ROC, and such details should be filed on or before 30th June of every year. Whatever are the details the company is going to file with the ROC, it will be duly certified by the auditor of the company. The lawmaker says that if you are a company which is other than a private company, which means you are a public company, and if your company has received some money from the directors by way of deposit, then such things should be disclosed inside the financial statement of the company. However, if you are a private company and your private company has received some money from the directors of the company or the relatives of the directors, then even such things should be disclosed inside the financial statements by way of notes to accounts. Whenever a company makes any kind of delay in repayment of deposits to its depositor, then yes, the company will be subject to a penalty rate of interest at the rate of 18% per annum for such delayed period. Over here, whenever your company had accepted deposits under the earlier act, that is as per the old act, that is as per Companies Act 1956, then such deposits shall be repaid as per the provision of section number 74. Till the time it is not been repaid, then for those deposits, if you are following the old rules, it is completely allowed. However, any new deposits the company is going to take, then such new deposits should be as per the provisions of chapter number 5 of this new act, that is Companies Act 2013. The lawmaker over here says that if any of the above mentioned rules, gets contravened, then in that case the company along with every officer who is in default shall be punishable. That is, company as well as every officer in default shall be punishable with a fine which may extend to 5,000 rupees. However, if the default continues, then for per day rupees 500 will be additional. For per day rupees 500 will be additional. Over here, my dear friends, we have successfully completed our entire revision of deposits under Companies Act 2013 along with Company Rules 2014 for acceptance of deposit. Yes, there is a definition for the word called as deposit. However, that entire definition is given under a negative list. As per Company Rules 2014, there are various things which are to be excluded, which are not to be considered as deposit. See, the general definition of the word deposit states that any money coming inside the company is considered to be deposit. But however, there are around 18 points. There are around 18 points through which the money will come inside the company, but it won't be considered as deposits. For example, any money received through central government or state government, or any money received through a foreign government, or any money received by a company through a way of a loan, or any kind of banking facility through a bank or a financial institute, any money raised by the company through issuing commercial papers, any money the company has received through intercorporate deposits, any money the company has received through an application towards the shares of the company. However, the shares should be allotted within 60 days. If it is not allotted, then the money should be refunded within 15 days. If not allotted, then, and if not refunded, then the money will be considered as deposits. So there are various negative points through which the company will receive money, but it won't be considered as deposits. So yes, my dear friends, this was our entire revision towards the topic called as chapter number 5 of Companies Act 2013, that was deposits. Thank you so much.